My name is Andrea Reed. I'm of counsel with the Boston-based IP firm Lando Anastasi. This short video segment will cover 2023's patent damages trends, cases, and expectations moving into 2024. First, a look back. In recent years, damage awards for patent infringement have been trending up. The dollar amount of these awards has been increasing into the 9 and even 10 figures, and the number of cases with awards over 100 million is also increasing. Simultaneously, the number of lawsuits filed by non-practicing entities, or NPEs, has been trending up too. In 2023, the top 5 patent damages awards were between 240 million and 470 million. 4 out of those 5 awards came out of either the Eastern or Western District of Texas. So how has the Federal Circuit reacted to record-breaking awards? By increasing scrutiny of patent damages, and 2023 was no exception. In the final month of 2023, the Federal Circuit overturned one of the largest verdicts in patent law history. The case is VLSI Technology v. Intel, originally filed in the Western District of Texas by a non-practicing entity. The Texas jury had awarded $2.18 billion, that's billion with a B, for infringing 2 patents. On appeal, the Federal Circuit remanded for a new trial on damages because it found error in an expert witness damages calculation. So what did the expert get wrong? The U.S. Code provides for the calculation of a reasonable royalty. Any reasonable royalty must seek to measure the value of the patented technology, and it must be apportioned to that value by separating out and excluding other value in economic products or practices. The problem in VLSI was that the expert based its royalty analysis not on the incremental technical benefit attributable to the infringing functionality, but rather on the entirety of the functionality. VLSI is notable for its heavy scrutiny of a damages calculation. The Federal Circuit scrutinized the damages expert's methodology and, peeling it back one more layer, the technical expert's methodology and testing because it was relied on and incorporated into the damages calculation. It would seem then that VLSI is a step in the right direction in controlling 10-figure damage awards, but that remains to be seen. In the meantime, the Federal Circuit is giving the non-practicing entity in that case an opportunity to correct its damages calculation in a new trial. So Intel could still end up owing hundreds of millions of dollars. Now, let's look at a case with a more modest damages award. Cyntec v. Chilisin is a 2023 Federal Circuit opinion originating out of the Northern District of California. It was a dispute between competitors with damages based on a market share lost profits theory. The jury awarded about 1.9 million in damages according to an expert witness calculation. The district court enhanced that number to about 5.6 million. On appeal, the Federal Circuit vacated the damages award. So what did the expert get wrong? The expert had relied on customer SEC filings, 10Ks, which included revenue received from services and products that didn't incorporate the infringing product. Cyntec, like VLSI, is an example of Federal Circuit scrutiny of an over-encompassing damages calculation. The takeaway from these 2 cases is that scrutiny is consistent regardless of amount, 2.18 billion versus 1.9 million, regardless of plaintiff type, NPE or competitor, and regardless of damages type, reasonable royalty in one case and lost profits in the other. There's one other 2023 Federal Circuit opinion worth mentioning here. It's Finjan v. SonicWall, also originating out of the Northern District of California and decided just 3 days before Cyntec. Like VLSI, Finjan was the non-practicing entity with an apportionment problem. The expert calculated damages based on so-called top-level functions with sub-features, but the expert failed to assess the individual value of nearly 100 sub-features and exclude the ones attributable to unpatented features. So what exactly is apportionment, and why is it so hard to get right? Imagine a patent covers only a small piece of a larger multi-component product. Calculating a royalty on the entire product would result in overcompensation. That's where apportionment comes in. The royalty base or royalty rate must be adjusted downward to reflect the value attributable to the infringing feature, and no more. The reason apportionment is difficult is that it requires patent owners to assign value to something that may never have been individually sold. There's no benchmark. Damages experts sometimes look to the smallest saleable unit for a royalty base, or they look to comparable licenses for the royalty rate. There isn't one right way to do it, which ironically is what makes it so hard. Moving on, I have one more update to share with you. The Federal Rule of Evidence governing admissibility of expert testimony was amended on December 2023. It's referred to as FRE 702. The amendments clarify that a court can't admit expert testimony unless the proponent establishes admissibility by a preponderance of the evidence. Also, the expert's opinion must reflect a reliable application of reliable principles and methods to the facts of the case. The purpose of these amendments were not intended to change the law. Their purpose is simply to clarify the correct standard because courts were frequently misapplying it by conflating admissibility with weight. But it's expected to result in more aggressive challenges to expert opinions and more critical review of expert opinions by district courts. How patent litigants in district courts react to the amended rule is definitely something to watch in 2024. This, combined with the Federal Circuit scrutiny of patent damages last year, may ultimately result in fewer admissible opinions and lower damages awards overall. Whether it will reign in the 9 and 10-figure awards remains to be seen. Well, there you have it, 2023's patent damages trends, cases, and expectations moving into 2024. I'm Andrea Reed, and I hope you found this summary helpful.